What if I told you that your green card, the very document you worked so hard to obtain, could be taken away in an instant, even if you followed every rule, paid your taxes on time, and built your entire life in America? There are 5 critical mistakes that could destroy everything you've worked for. And the scariest part, most people don't even realize they're making these mistakes until it's too late. Stay with me, because what you're about to learn could be the difference between keeping your American dream alive and losing it all in a matter of weeks. Welcome to U.S. Visa Updates, your trusted source for critical immigration information that affects millions of people living legally in the United States. I'm here to guide you through the complex world of immigration law. And today's topic is one of the most important we've ever covered. We're talking about permanent residents, visa holders, and legal immigrants who are doing everything right, or so they think, but are unknowingly standing on the edge of a cliff. The immigration landscape has transformed dramatically, and what might have been overlooked just a few years ago can now trigger immediate deportation proceedings. This isn't about fear-mongering. This is about arming you with the knowledge you need to protect yourself, your family, and your future in this country. By the end of this video, you'll understand exactly which actions and situations pose the greatest threat to your legal status. More importantly, you'll know precisely what steps to take to safeguard your position and avoid the devastating consequences that have already impacted thousands of immigrants this year alone. So, if you or someone you care about holds a green card, work visa, or any form of legal status in the United States, this information is absolutely essential. Let's dive in. The first major threat to your legal status involves serious criminal convictions, and this is where things get particularly complicated. The term you need to understand is aggravated felonies. Now here's where it gets confusing and dangerous. An aggravated felony under immigration law doesn't necessarily mean it was classified as a felony by your state court. Yes, you heard that right. Your state might have charged you with a misdemeanor. You might have paid a small fine, served no jail time whatsoever, and walked away thinking the matter was settled. But under federal immigration law, that same offense could be classified as an aggravated felony, and that classification changes everything. The federal immigration system operates under its own set of rules, and these rules are often far more severe than what you'll encounter in your local criminal court. Offenses that fall into this dangerous category include theft regardless of the amount stolen, fraud even if it seems minor to you, assault, which can include situations where no physical injury occurred, any form of violent behavior, including threats or intimidation. The critical factor here isn't how much time you spent in jail or whether you spent any time behind bars at all. The federal system looks at the nature of the crime itself and makes its own determination about severity. Let me paint you a picture of how this plays out in real life. Imagine you're a green card holder who's been living in the United States for 15 years. You own a home, your children were born here. You've built a successful career. One night, you make a mistake. Maybe you get into an argument that turns physical. Maybe you're accused of taking something that doesn't belong to you. The local prosecutor offers you a deal. Plead guilty to a misdemeanor, pay a fine, maybe complete some community service, and you can move on with your life. It seems like the smart choice. You want to put this behind you quickly. You don't want the expense and stress of a trial. So, you accept the plea deal, pay your fine, complete your community service, and assume the chapter is closed. But here's the nightmare scenario. Months later, maybe even years later, you apply to renew your green card or you travel outside the United States and attempt to return, or immigration authorities conduct a random review of your file. Suddenly, you receive a notice to appear before an immigration judge. That misdemeanor conviction you thought was behind you, immigration authorities have classified it as an aggravated felony, and once that happens, you're facing mandatory detention and almost certain deportation. There are very few defenses available. The judges have limited discretion. Your 15 years of lawful residence, your American children, your home, your career. None of it may be enough to save you. This is why the advice I'm about to give you is absolutely critical. If you are ever arrested, if you are ever charged with any crime, no matter how minor it seems, you need 2 attorneys, not 1. You need a criminal defense attorney who understands the charges you're facing in state court. But, just as importantly, you need an immigration attorney who can analyze those charges through the lens of federal immigration law. These 2 attorneys need to work together before you accept any plea deal, before you make any statements, before you take any action whatsoever. A decision that seems insignificant in criminal court can be catastrophic under immigration law. Don't let a moment of crisis destroy decades of lawful presence in this country. The second major threat involves drug charges, and this is an area where the law shows almost no mercy. Many people operate under the assumption that minor drug offenses, particularly possession of small amounts, won't seriously impact their immigration status. This assumption is not just wrong, it's dangerously wrong. The reality is that drug convictions trigger some of the harshest consequences in all of immigration law. Let's be very specific about what we're talking about here. Possession of cocaine, regardless of the amount. Possession of heroin, even a trace amount. Possession of prescription medications that weren't prescribed to you, even if you're holding them for a friend or family member. Possession of methamphetamines, ecstasy, or virtually any other controlled substance. The amount doesn't matter. You could be caught with a single pill, a tiny residue in a bag, or a minuscule quantity in your pocket. Under immigration law, that's enough to initiate deportation proceedings. Now, there is one very narrow exception, and it applies only to marijuana. If you're charged with possession of marijuana, and the amount is less than 30 growing, and this is your first offense, there's a possibility you might avoid immigration consequences. But notice how many conditions have to line up perfectly for this exception to apply. Less than 30 g, which is roughly 1 ounce. First offense only. If you have any prior drug-related incidents on your record, this exception disappears. And even with this exception, you're walking a tightrope. Different jurisdictions interpret this exception differently, and what saves you in one situation might not protect you in another. Here's another crucial point that catches people off guard. Let's say you're arrested on drug charges. You hire an attorney. You work out an arrangement. Maybe the prosecutor agrees to dismiss the charges if you complete a drug treatment program. Maybe you're offered a diversion program where the charges will be erased from your record if you stay clean for a certain period. You complete the program successfully. The charges are dismissed. Your criminal record shows no conviction. You breathe a sigh of relief and assume you're in the clear. But immigration authorities don't always see it that way. If at any point during the criminal proceedings you admitted to possessing the drugs, even if no conviction resulted, immigration officials can use that admission against you. That's right. The admission of guilt alone, even without a conviction, can be grounds for deportation. This is why you need specialized immigration advice the moment you're facing drug charges. What you say, what you admit to, how your case is resolved, every single detail matters under immigration law in ways that aren't immediately obvious in criminal court. Think about the stakes here. You could be a permanent resident who's lived in the United States for 20 years. You could have children who are American citizens. You could own a business that employs dozens of people, but one mistake, one moment of poor judgment involving drugs can unravel everything. The immigration system doesn't care about your contributions. It doesn't care about your family ties. When it comes to drug offenses, the law is rigid, unforgiving, and brutally efficient. The third major threat involves family violence and domestic disputes. And this is an area where the immigration consequences are severe and far-reaching. Any act of violence, any threatening behavior, any violation of a protective order involving someone in your household can trigger deportation proceedings. And the definition of who counts as a household or family member is much broader than most people realize. We're talking about your current spouse, obviously, but also your ex-spouse, even if you've been divorced for years, your children, including stepchildren, and adopted children, your cohabiting partner, even if you're not married, your parents or in-laws who live with you. Essentially, anyone who shares your household or has a familial relationship with you falls under this umbrella. And the type of conduct that can get you in trouble is broader than you might think. Physical altercations are the obvious example. If you strike, push, shove, or physically harm a family member, you're facing serious immigration consequences. But it goes beyond physical violence. Unlawful touching, which can include grabbing someone's arm during an argument or blocking their path. Verbal threats, even if you never intended to carry them out, and even if no physical contact occurred, violating a restraining order or protective order, even if the violation seems technical or unintentional. All of these actions can be classified as domestic violence under immigration law. Here's what makes this particularly dangerous. In many jurisdictions, domestic violence charges are prosecuted as misdemeanors. You might not face any jail time. You might be offered anger management classes or counseling as part of a plea deal. The local prosecutor might frame it as a minor offense that won't seriously impact your life. But under federal immigration law, domestic violence offenses are treated with extreme severity. A misdemeanor domestic violence conviction can make you deportable regardless of how minor the incident seems or how much time has passed since it occurred. Let me give you a real-world scenario. You're in a relationship that's falling apart. Emotions are running high. During an argument, your partner calls the police. Maybe there was pushing, maybe there were raised voices, maybe the police simply err on the side of caution and make an arrest. You're charged with domestic violence. A prosecutor offers you a deal. Plead guilty to a misdemeanor. Take some classes and avoid jail time. It seems reasonable. You want to move forward. You accept the deal. But here's what just happened. You've now been convicted of a deportable offense. When immigration authorities review your file, whether it's during a green card renewal, a naturalization application, or a random audit, they'll see that conviction. And unlike criminal court, where judges have discretion and can consider mitigating circumstances, immigration judges have very limited flexibility when it comes to domestic violence convictions. Your legal status, your years of lawful residence, your family ties in the United States, all of it is now in jeopardy because of a single misdemeanor conviction. This is why consulting an immigration attorney before accepting any plea deal in a domestic violence case is absolutely essential. There may be alternative resolutions that protect your immigration status. There may be ways to structure the charges or the plea agreement that avoid the most severe immigration consequences. But you'll never know these options exist unless you seek specialized legal advice before making any decisions. The fourth major threat is immigration fraud. And this is particularly insidious because it can come back to haunt you years, even decades after the original application or filing. Immigration fraud encompasses a wide range of conduct. Lying on immigration forms, even about matters that seem insignificant. Using falsified or forged documents to support an application. Obtaining legal status through a fraudulent marriage where the marriage was entered into solely for immigration benefits, misrepresenting material facts during interviews with immigration officials. Any of these actions constitute fraud, and the consequences are severe. Here's what makes immigration fraud so dangerous from a timing perspective. Let's say you obtained your green card 20 years ago. You've been a lawful permanent resident for 2 decades. You've built an entire life in the United States. You've raised children here, bought property, established a career, integrated into your community. You haven't had a single run-in with the law. By every measure, you've been a model resident, but immigration authorities can investigate past applications at any time. There's no statute of limitations on immigration fraud. If new evidence emerges, if an informant comes forward, if a routine review uncovers discrepancies in your original application, immigration officials can reopen your case. They can revoke your green card. They can initiate deportation proceedings, and your 20 years of lawful presence won't protect you if they determine your status was obtained fraudulently. This applies not just to the original green card application, but to every immigration benefit you've ever received. Work permits, travel authorization documents, applications for citizenship, petitions for family members, every form you've ever submitted, every statement you've ever made to an immigration official, every document you've ever provided in support of an application, all of it can be scrutinized years later. Common scenarios where fraud issues arise include marriage-based green cards where the marriage ended shortly after status was obtained, employment-based applications where the job offer wasn't genuine or where the qualifications were exaggerated, asylum applications where the claimed persecution didn't actually occur or was embellished, family-based petitions where relationships were misrepresented or documentation was altered. The key takeaway here is that honesty isn't just the best policy, it's the only policy. Every piece of information you provide to immigration authorities must be accurate and truthful. Not partially true, not mostly accurate, but completely and fully honest. Even small misrepresentations, the kind you might think of as white lies, can have devastating consequences when examined under federal law. If you've made mistakes on past applications, consulting with an immigration attorney about potential remedies or disclosures is far better than hoping the issue never surfaces. The fifth threat might seem almost trivial compared to the others, but it's an administrative requirement that can create serious problems, especially when combined with other issues. Green card holders and certain other categories of legal residents are required by law to notify immigration authorities of any change of address within 10 days of moving, not 10 business days, 10 calendar days. This requirement is codified in federal law and failing to comply is technically a violation. Now, realistically, immigration authorities aren't going to initiate deportation proceedings against you solely because you didn't update your address on time. But here's where this seemingly minor violation becomes dangerous. If you're ever in removal proceedings, if immigration authorities are investigating you for any reason, if there are any questions about your status, the failure to update your address can be used against you. It becomes part of a pattern of non-compliance. It suggests to immigration officials and judges that you're not taking your legal obligations seriously. It can undermine your credibility if you're trying to fight deportation or demonstrate good moral character. Updating your address is remarkably simple. You can do it online through the Immigration Services website. The process takes just a few minutes. Yet thousands of people overlook this requirement every year, often because they're unaware it exists or because they assume it's not enforced. Don't make this mistake. Every time you move, set a reminder to update your address with immigration authorities within 10 days. It's a small action that protects you from potential complications down the line. Now let's talk about the broader context of immigration enforcement in the current environment. The pace of deportation proceedings has accelerated dramatically. Cases that once took months or years to resolve are now moving through the system at unprecedented speed. Immigration judges are under pressure to clear backlogs, which means hearings are shorter and decisions are faster. What might have been considered a minor infraction in previous years can now lead to immediate detention and swift removal from the country. This accelerated pace means that the margin for error has shrunk considerably. If you find yourself in immigration court, you may have very limited time to mount a defense, gather evidence, or explore options for relief. This is why prevention and preparation are so critical. By the time you're facing an immigration judge, your options may already be severely limited. Call to action and protective measures. So, what should you do with this information? How do you protect yourself and your family from these threats? Let me give you concrete, actionable steps. First and foremost, if you ever face any legal trouble, any interaction with law enforcement, any criminal charges, no matter how minor they seem, you must consult with an immigration attorney before making any decisions. This is not optional. Prosecutors in criminal court are focused on resolving criminal charges efficiently. They're not thinking about immigration consequences, and they have no obligation to warn you about how a plea deal might affect your legal status. What looks like a generous offer from a criminal law perspective could be a disaster from an immigration standpoint. Second, maintain absolutely honest and accurate records with immigration authorities. Every form you submit must be truthful and complete. Don't omit information because you think it might cause problems. Don't embellish or exaggerate to make your case stronger. Provide accurate information and let the chips fall where they may. Honesty protects you in the long run, even if it creates short-term complications. Third, keep your address current with immigration authorities. Make this part of your moving checklist. As soon as you know your new address, update it online. Keep confirmation of the update for your records. This simple administrative task can prevent complications if you're ever in immigration proceedings. Fourth, maintain comprehensive documentation of your life in the United States. Keep tax returns, employment records, lease agreements or property deeds, children's school records, medical records, evidence of community involvement, anything that demonstrates your ties to this country and your compliance with the law. If you ever need to fight deportation, this documentation can be crucial in demonstrating that you deserve discretionary relief. Fifth, stay informed about changes in immigration law and enforcement priorities. The immigration landscape shifts constantly. Policies that were in place last year might not apply today. Enforcement priorities change with new administrations and in response to political pressures. By staying informed, you can anticipate potential issues and take proactive steps to protect yourself. Sixth, if you have any skeletons in your closet, any past mistakes on immigration applications, any situations that might constitute fraud or misrepresentation, consult with an immigration attorney now while you're not in removal proceedings. There may be options for coming clean, correcting the record, or obtaining waivers that aren't available once deportation proceedings have begun. Finally, treat your legal status as an ongoing responsibility, not a one-time achievement. Your green card isn't a finish line. It's an obligation that requires continuous attention and compliance. Follow the law meticulously. Cooperate with authorities when required. Seek professional guidance whenever you're unsure about the immigration implications of any action. This level of vigilance might seem exhausting, but it's the price of maintaining legal status in an enforcement environment that shows little mercy for mistakes. The reality we face in this current immigration climate is stark and unforgiving. Your legal status, whether it's a green card you've held for decades or a work visa you obtained recently, is not an absolute guarantee of your right to remain in the United States. Criminal convictions, even those classified as minor offenses by state courts, can trigger immediate deportation. Drug charges, including possession of trace amounts, can destroy your immigration status. Family disputes that result in domestic violence charges can make you removable, regardless of how much time has passed. Immigration fraud, even from applications filed years ago, can surface and result in revocation of your status. And administrative violations, like failing to update your address, can compound other problems and undermine your credibility when you need it most. The immigration system moves faster than most people expect, and the consequences are immediate and often irreversible. But here's the empowering message I want you to take away from this video. Knowledge is power. By understanding these risks, by taking the protective measures we've discussed, by maintaining accurate records and seeking professional guidance when necessary, you can significantly reduce your risk of facing deportation or other serious immigration consequences. Your legal status is valuable. For many of you, it represents years of effort, sacrifice, and hope for a better future. It's worth protecting with every tool at your disposal. Stay informed, stay compliant, and stay proactive. Don't assume that because you've been here for years without problems that you're immune to immigration enforcement. Don't assume that minor legal issues won't affect your status. Don't assume that the immigration system will give you the benefit of the doubt or multiple chances to correct mistakes. Here at US Visa Updates, we're committed to bringing you the most current, accurate, and actionable immigration information available. If this video helped you understand the risks to your legal status and how to protect yourself, please hit that like button and subscribe to our channel. Share this video with friends, family members, or anyone you know who holds legal status in the United States. This information could literally change someone's life. And remember, while this video provides important general information, it's not a substitute for personalized legal advice. Every immigration situation is unique with its own specific facts and circumstances. If you're facing any of the situations we discussed today, or if you have concerns about your immigration status, please consult with a qualified immigration attorney who can analyze your specific situation and provide tailored guidance. Your American dream is worth fighting for. Your family's future in this country is worth protecting. Stay vigilant, stay informed, and stay safe. Until next time, this is US Visa Updates, keeping you informed about the immigration matters that affect your life. Thank you for watching, and we'll see you in the next